Karen Reed's second trial has started as jury selection is underway. We obviously don't know the result yet, but it's going to definitely be a different trial from the first one. One reason the trial is going to be so different is that Judge Cannone has barred some important information, some important evidence about a third party who might have killed John O'Keefe, according to Karen Reed. This time around, the judge is banning any argument or evidence that 17-year-old Colin Albert might be the person who killed John O'Keefe. Is this part of a cover up? Is Judge Cannone in on it? Or did she get this ruling right? We're going to be looking at that very question in this video. Now, let's back up just a little bit and give a quick reminder of what the case is all about. Karen Reed had been out at bars with her boyfriend, John O'Keefe. O'Keefe was a Boston police officer, and the couple ran into another Boston police officer, Brian Albert. As the bar was shutting down, Brian Albert invited people over for an after party at his house. Karen Reed didn't feel like going, so she dropped her boyfriend, John O'Keefe, off in front of Brian Albert's house just as a winter storm was moving in. From that point on, the prosecutor and Karen Reed have wildly different views of what happened. The prosecution says Karen Reed backed her car into John O'Keefe. He flew through the air, and the combination of his injuries and then exposure to the cold through the night killed him. Karen Reed says John O'Keefe went into that party, that only a massive cover-up and incompetence kept the police from realizing that John O'Keefe was actually murdered by someone at that party. At the first trial, Karen Reed suggested 3 people connected to that home might have had a motive or a desire to kill John O'Keefe. Judge Cannone balked at letting that evidence in, but ultimately she did let it in at trial. The 3 people were Brian Higgins, who had kind of a brief romantic moment, I guess you'd call it, with Karen Reed behind her boyfriend's back. Brian Albert was the Boston police officer who owned the home where John O'Keefe was headed to the after party. And Colin Albert was 17 at the time, Brian Albert's nephew. We'll hear more about Colin in just a minute. Judge Cannone has ruled that Karen Reed cannot talk about one of those 3, in fact, maybe the most intriguing suspect of the 3. She hasn't said yet one way or the other whether Karen Reed will be allowed to talk about and present evidence about the other 2. Let's talk about this new ruling and how it's going to dramatically change the character of this next trial of Karen Reed. And I want to start with why Karen Reed might get to present this evidence at all. I mean, after all, this trial is about Karen Reed. It's about whether she did it, not whether someone else did. So why are these other people relevant at all? Well, the Constitution gives Karen Reed the right to present evidence that she is not the one who killed John O'Keefe, that someone else did it. It also gives Karen Reed the right to argue that the investigation by the police was really poor, substandard, that they missed leads, that they botched evidence collection, that they ignored potential suspects in a rush to charge Karen Reed with the murder of her boyfriend. So in a new order, Judge Cannone acknowledges that Karen Reed has the right to tell the jury about third parties who might have committed the crime. Let's take a look at the document. She said, the opportunity to present third-party culprit evidence is guaranteed by the Due Process Clause of the 14th Amendment because it is rooted in the right of criminal defendants to a meaningful opportunity to present a complete defense. Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible provided that it has substantial probative value and will not tend to prejudice or confuse the jury. Let's start with Colin Albert. At the first trial, Karen Reed argued that Colin Albert, the 17-year-old nephew of Brian Albert, had been at the house earlier in the night, and he might either have still been there or he might have looped back around to the house, or maybe even he hadn't quite left yet when John O'Keefe arrived. So Karen Reed's lawyers played a Snapchat video where Colin Albert threatened some other people, not John O'Keefe, but some other people. And on cross-examination, Colin Albert acknowledged that the videos were threatening. Let's take a look at what happened on cross-examination.
You indicated on cross-examination you've never been in a fight. No.
Indicating that you have no violent tendencies and no violent proclivities, correct?
Nope.
What were you saying on that video?
That I would beat them up.
So when you said, I will beat you up and I will beat your ass, was that a friendly invitation?
No.
Were you threatening these advantage boys, guys, whoever they are?
Yeah, kinda.
Were you threatening them with violence?
Kinda, yeah.
So you're threatening them yet again, a second time.
Yeah.
What does pull up mean?
Like, come by?
Yeah, meaning get over here. Mm-hmm. Right?
Yep.
Because when you do, I'm gonna beat you up, right?
Yeah.
Meaning I'm gonna fight you and I'm gonna put you down, correct?
Correct.
That was your threat to them.
Correct.
Reed's team also showed a picture of Colin Albert that was taken a couple of weeks after John O'Keefe died. Colin Albert had his arms around a couple of buddies, and you could see that his knuckles were scraped. Let's take a listen to what happened at trial about that.
And those were taken on that photo was taken on February 26, 2022.
Yes.
At the place called, I think it's called Fenway Johnny's, right?
Correct.
Okay. Are you in that photograph?
Yes.
Which person are you?
In the middle.
And about what time of day was it? That's you in the middle?
Correct.
Okay. About what time of day was this taken?
Not sure.
Was it at an event of some sort or just you were at a bar?
Just at a bar.
Okay. I want you to take a look at your right hand. Can you see from there clearly your right hand?
Yes.
What do you notice about your right hand?
It's cut up.
Your knuckles are injured, correct?
Correct.
How'd you get those injuries, Mr. Albert? We can pull the lights up.
I was at a party, my house party my senior year, and I remember it being icy out, and it was kind of like a steep hill of a driveway, and I was walking up the driveway, and I slipped down the driveway, and I tried to catch myself, but I had something in my left hand, so I had tried to brace myself with my right hand, and I ended up sliding a little bit down the driveway.
What'd you have in your left hand?
If I remember, it was either my phone or a beverage.
So, according to you, you fell on ice and injured your knuckles, as we just saw in that photograph, right across the top of your knuckles.
Correct.
Okay. So you fell onto, what, pavement, asphalt?
Yes.
And you braced yourself when you fell, your entire body weight, by putting your right hand down in a fist, and you injured your right fist, just the top of the knuckles on your right fist when you fell down.
Correct.
Seriously?
Objection, Your Honor.
Sustained.
Karen Reed's lawyers also suggested that that was not the only time that Colin Albert had bruised or scraped knuckles. Here's how the testimony went at trial.
July 27th, 2023. Do you remember being at another hearing?
Yes.
You remember being questioned by some attorneys?
Yes.
Do you remember the question about the condition of your fist? Literally at the hearing?
Yeah.
You were asked questions by the questioner about the condition, the physical condition of your fist, weren't you?
Correct.
And you claimed at that time, well, let me back up for a second and ask a different question. They were asking because you had open injuries on your right knuckles yet again, didn't you?
Correct.
You said, it must have been hitting a heavy bag, right?
Yeah.
At this point, Karen Reed's attorneys are not going to be allowed to present any of this evidence to the jury at this second trial. All of the evidence that you just saw about Colin Albert will be excluded unless the judge changes her ruling for something that gets opened at trial. Karen Reed's attorney also at trial referred to a feud between Colin Albert and John O'Keefe. The implication that they were making was that the scraped knuckles, the violent video, the feud all meant that Colin Albert was just the kind of guy who would go after John O'Keefe. The judge has ruled that there is not nearly enough evidence to connect Colin Albert to the death of John O'Keefe. Now, Colin Albert had been at the house that very night, But the prosecutor argued that phone evidence and testimony showed that a friend picked him up and that he left before John O'Keefe arrived. Here's what the prosecutor for the Commonwealth said during closing arguments.
12:10 a.m. From the waterfall video, you have Ms. McCabe, Ms. Kolakithis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert, Nicole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe, and then is driven home. 1 minute later, 12:11, Mr. O'Keefe is then on the waterfall video walking out with cocktail glass in his right hand. You have testimony recalled, and you have text messages in regard to Colin Albert when he gets picked up from home.
Mr. Lally, 5 minutes.
Yes, sir. Colin Albert, Miss Allison McCabe, Brian Albert, Nicole Albert, Caitlin Albert, Brian Jr., all indicating that it was picked up around that time at 12:10 a.m. You have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them goodnight before he goes to bed.
So the prosecutor's argument is there's no possibility, there's no realistic evidence that Colin Albert was present at the home, that he even could have done this. Karen Reed's team did point to some odd things about the phone data, about where the friend's phone went that night that would suggest that maybe they didn't go straight home, at least not the friend. But Judge Cannone didn't believe any of that, and she specifically didn't believe that there was any evidence that would bring Colin Albert back to the Brian Albert home, that at no point did he head back over there to where his uncle lived. Judge Cannone said there's just not enough information here, enough evidence to have Colin Albert even present at the scene or to give him a motive. Let's take a look at what she said. As to Colin Albert, the defendant's proffer contains no additional evidence than that presented at the first trial, and it is insufficient to support a preliminary finding that Colin Albert had the motive, intent, and opportunity to commit the crime. The evidence of opportunity is wholly inadequate. There is no evidence that Colin Albert was at 34 Fairview when the defendant and Mr. O'Keefe arrived at the home. They cite a case. Evidence at the first trial was that Colin Albert had already been picked up by the time O'Keefe and the defendant arrived at 34 Fairview. As to motive, the defendant contends that Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to O'Keefe's death, and that Colin Albert had thrown beer cans on O'Keefe's lawn and swore at him. There was, however, no evidence substantiating these claims at the first trial. Even if there was evidence of some ill will between O'Keefe and Colin Albert, motive alone is not enough to demonstrate third-party culpability. Moreover, the theory that Colin Albert is the third-party culprit because he had scraped knuckles at some point after O'Keefe's death had been seen in a video drunkenly taunting others with no connection to O'Keefe and apparently was not named in police reports is speculative at best. Allowing such feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth and would only serve to confuse the jury. Accordingly, evidence that Colin Albert is a third-party culprit is excluded from trial. The testimony about Colin Albert at the first trial was explosive, but this jury will never see it, which will make at least some impact on the trial. But there were two other potential suspects. The judge has not yet ruled them out, or for that matter, definitively allowed the defense to present evidence that they committed the crime. Here's what she says about Brian Higgins, the one with the semi-romantic relationship with Karen Reed, and Brian Albert, who owned the home where the after party was being held and where John O'Keefe's body would be found in the front lawn the next morning. Just like at the last trial, the judge is holding her ruling until trial actually begins, until she sees the evidence come in. But she seems even more reluctant to let the testimony in at the second trial than she was at the first trial. And it's pretty fair to say she was very reluctant last time. Let's take a look at the order and what she said. As to Brian Albert and Brian Higgins, the defendant's proffer is barely sufficient, and the history of the first trial casts doubt on the seriousness of the claim. However, To protect the defendant's right to a fair trial and in recognition of the fact that the defendant has no burden to prove anything under our law, the court will take the same incremental approach as it did the first trial. Defense counsel are ordered not to mention potential third-party culprits in opening statements, but counsel will be allowed to develop the evidence at trial if possible, and counsel may seek an appropriate instruction if warranted after the evidence is concluded. Though the court may ultimately exclude the proposed third-party culprit evidence, or counsel may abandon the theory, that does not mean that the defendant cannot offer the evidence to show the inadequacy in the police investigation, provided that the proper foundation has been established. In other words, they will be allowed to at least show that the police investigation did not look into some of the people who might have been actually responsible for this, such as the people inside the home, the homeowner, such as the person with the relationship with Karen Reed. They would still be allowed to discuss some of that. It would not be the same as arguing that those people might have had a motive, opportunity, and might have actually committed the crime. Here is the upshot of what the judge is going to allow. The judge says it is hereby ordered that the defendant is precluded from raising a third-party culprit defense alleging Colin Albert is culpable for John O'Keefe's death. The Commonwealth's motion is allowed as to Colin Albert. The defendant is not prohibited from raising a third-party culprit defense as to Brian Albert and Brian Higgins at this time. Counsel cannot mention potential third-party culprits in opening statements, but will be given the opportunity to develop the theory through relevant, competent evidence at trial. So we don't know yet what the judge will rule on Brian Higgins and Brian Albert, but in the end, it is a constitutional right to present third-party evidence. My guess is that she will make the same decision that she made at the last trial, that she will decide to allow that evidence into this trial. So is this part of a cover-up, particularly the part where Judge Cannone has ruled out any evidence that Colin Albert was actually a participant? Is she protecting Colin Albert? I don't doubt that she is somewhat protecting Colin Albert. He's still relatively young. She's not exactly a fan of the defense. But in this instance, I do think there was legal ground for the decision that she's making here. The evidence from the first trial did show that Colin Albert left the home beforehand, and there were some hints and some insinuations that maybe he had gone somewhere other than straight home, like he said, or at least that the driver of the car that picked him up hadn't gone straight to her house, but it stopped short of there being any actual evidence that he had doubled back around and come back to the scene, or that he was there at the exact time. So I think an appellate court is pretty likely to say, okay, this call by Judge Cannone is okay. We're not going to overturn on this. Is it going to make a difference at trial not having this particular evidence available? For sure, some of the jurors from the first trial did not believe that Colin Albert could have been responsible for the death of John O'Keefe. The way we know that is that several jurors after the trial said that the entire jury agreed that Karen Reed did not murder John O'Keefe and that she did not leave the scene knowing she had caused personal injury or death, but they were hung up on manslaughter. So what that tells us is that at least some of the jurors believed that John O'Keefe had died because of a car accident. That means that at least some of the jurors believed that maybe Karen Reed backed into John O'Keefe, and at least some of them did not believe that there was an attack from a third party, whether it be Colin Albert or Brian Higgins or Brian Albert. So on the one hand, you could argue that losing this evidence isn't really that big a deal because the jury wasn't buying it anyway. But I think the evidence flavored the trial in a really important way. The defendant had a fair amount of evidence to suggest that the people inside 34 Fairview, inside that home, were hiding evidence, and to argue that the Massachusetts police were covering things up. But the Colin Albert evidence took it a step further because it suggested that the people in that house might have been violent too. There were some pretty vague hints around Brian Albert having been investigated for that, but apparently the investigations did not find any wrongdoing. I'm guessing the judge is probably not even going to let that evidence in this time around on the second trial. The Colin Albert evidence was very unlike that. It was very tangible. There was a video. There were skinned knuckles, and the jury could see that in a photograph. From Karen Reed's standpoint, if she isn't allowed to use this evidence, it will hurt. It probably won't affect the result, but I think it will be something she'll miss. I think that it will change the character of the trial somewhat. But remember, the judge has not yet ruled on whether or not to let the defendant even argue that Brian Albert and Brian Higgins are potential third-party suspects. From Karen Reed's point of view, it's really helpful to have two different people as suspects. So if the evidence comes in a little weak against one, there's still another person the jury can consider. But by far the stronger of the two is Brian Higgins, since he did have that semi-romantic interlude with Karen Reed while she was dating John O'Keefe. And he pushed for John O'Keefe to attend the party. Higgins and Albert both destroyed their phones the day before they were going to have to turn them over to authorities, which just looks really, really bad, particularly for people in law enforcement. Higgins destroyed his phone in a particularly dramatic way by breaking the SIM card and driving to a military base to dispose of it in a large trash dumpster. If for whatever reason the judge rules out the third-party culprit evidence about Brian Albert or Brian Higgins, that will be a real blow for Karen Reed. But if the judge rules out the evidence against both, that's going to be an extremely serious loss for Karen Reed. She still may be able to get a lot of that in just to show that law enforcement really did a pretty poor investigation. It should have looked a lot harder at other potential suspects instead of immediately focusing on Karen Reed. But obviously, Karen Reed would rather have all of that evidence in. We're going to have to wait until trial to see how it all shakes out. But do remember this. Last time, Judge Cannone made a similar ruling, and she ended up deciding to let the evidence in. I think it's pretty likely that she's going to come out the same way this time. This is not the only thing that's going to be different about this second trial. There is a new prosecutor in town and numerous new rulings by Judge Cannone, along with lots of new experts who will be testifying this time around. So it will not be the same trial, but will it make a difference for Karen Reed? Like and subscribe as we find out together.